All right, good morning, everybody, and welcome to this month's risk reduction, risk management class, where we're going to be talking about fire hardening and defensible space. There are three forms. Two have been revised and one is brand new. The fire hardening and defensible space disclosure and addendum, the FHDS, has been revised. I hesitate to use the word simplified because it's not really been simplified, but maybe a better word is it's been streamlined a bit. It's actually, I think, simpler to understand. And by the end of today's class, you're going to have a real good handle on how to deal with that form. The new form, the Defensible Space and Decision Tree, the DSDT, that's a new form designed to help sellers fill out the form, the FHDS, because the FHDS is really a seller disclosure. It's not an agent disclosure. So be careful when you advise your seller. It's probably appropriate for you to give them quite a bit of advice because this is an area that we have a little more expertise in than the sellers do, but you want to be sure to let them know that if they have any questions, they might want to consult their own legal counsel. And then finally, the Wildfire Disaster Advisory has been modified as a result of modifying the FHDS, and I'll talk about that as we get into it. So let's get right into today's presentation, and I'll open up my, let's see, okay, there we go. All right, everybody can see that, I hope. And of course, as usual, don't hesitate.
We cannot see your screen.
You cannot see it. Okay, let me go back and share my screen, which I forgot to do. Now, can everybody see my screen?
Yes, we can.
Excellent, excellent. Okay. All right. Any questions at all regarding this material or any material for that matter? Any questions? Don't hesitate to call me during the business day, during the business hours. It's best to call my landline, and I apologize. This is an older slide. If you got a pen, let me write down. Let me give you my direct dial number, which is 858-201-7115. Lindsay, maybe you could put that in the chat for everybody. But otherwise, you call this number, extension 1001, will get me. Email me. That's an old email too. I'm sorry, I pulled the wrong slide. A better email is walt@remaxconnectionca.com. What has not changed is my cell number. I have a brand new iPhone, which I love, and the phone number is still the same. 858-386-3110. Evenings and weekends, it's best to text me. The phone lights up when I get a text, so it gets my attention. I never wander far from it. I often do not have the ringer on. If you do dial and call me and leave me a voicemail, I will get back to you. But texting is, tell me, hey, Walt, call me, and I will be happy to call you. All right, let's get into today's material. Fire hardening and defensible space disclosure and addendum, and the defensible space decision tree. We'll also mention the wildfire disaster advisory. So let's take a look at the FHDS. Many of you are familiar with it, and it's been modified to make it a little more, make more sense, be more intuitive, and to better deal with the civil code, both state law and any local laws. So we'll take a look at the form kind of in detail. Okay, the first is a law applicability. So the law, there's both a fire hardening disclosure law, and there's also a defensible space section of the law, and they are separate in one important provision, and that is for fire hardening, they have 4 requirements for that to be necessary. For defensible space, only the first 3. So let's take a look at this. If the property doesn't meet the conditions stated in either 1A or 1B, then there's no requirement to complete this form. And the old form was an advisory as well as a disclosure and addendum. So we recommended that if you had any questions at all, go ahead and provide it because of the advisory portion. No longer is that necessary. I would not provide this form unless the property meets the standards I'm going to review with you, but I would recommend, and in fact, we're going to require that the wildfire disaster advisory be provided to buyers. So if you have buyers, you want to be sure to give your buyer that wildfire disaster advisory, the WFDA. Okay, so the fire hardening disclosure is required if the 4 conditions are met. And the first condition is the property is residential 1 to 4 units. The second condition is that a TDS is required. So, for example, if a property is a TDS exempt sale, a successor trustee, a probate, then this form is not applicable regardless of where the property is located, but I would still provide the buyer with the wildfire disaster advisory, even though this form is not necessary because the seller is exempt from a TDS. The third thing is that the property is in a high or very high fire hazard severity zone. And we'll talk a little bit about how you determine that in a minute. And then finally, if the improvements to the property were constructed before 2010. So if the property doesn't meet all 4 of these conditions, then the fire hardening disclosure is not necessary. The fire hardening disclosure is basically disclosing to a buyer vulnerabilities the property might have. Well, since January 1st, 2010, building permits required these vulnerabilities be addressed and constructed in a way, the property constructed in a way that they would not have these vulnerabilities. So if your property was built in 2012, for example, even though it's in a high or very high fire zone, even if you are going to provide the TDS, even if it is a single family home, Item 4, it was constructed after January 1st, 2010. You would not need to do the fire hardening disclosure. Still provide the wildfire advisory, but the disclosure portion of the form does not need to be filled out because of the age of the property. Okay. Like I said, if any of these 4 conditions is not met, the seller does not have to answer the questions in the subsequent paragraph 2B, which we'll look at in a minute. Defensible space compliance, the requirements to provide defensible space compliance are a little broader than the fire hardening disclosure requirements. So what does that mean? What that means is it's a residential property that contains 1 to 4 units, just like the fire hardening requirements. The seller is required to do a TDS, and the property is located in very high or very high fire hazard severity zone. But notice there is no caveat regarding when the property was constructed. It doesn't matter if the property was constructed yesterday. You still have to do the defensible space compliance of this form if these other 3 conditions are met. So I hope I'm kind of clear. If you have a question, either put it in the chat or when I'm done, we'll take questions. But again, what I'm saying is you may be exempt from the top portion of the form, paragraph 2, but if it's in a high and very high fire zone, a TDS is required and it's 1 to 4 units, you will not be exempt from paragraph 3 because of the fact that the age factor doesn't kick in, the date of the construction. Okay, so how do you determine whether it's in a high or very high or fire zone? There's a few different ways, and Carr is lobbying the natural hazard zone disclosure companies to modify their reports a bit. Their reports are governed by a civil code that's not exactly compatible with the fire hardening and defensible space sections of the code. So they do reporting that's not as straightforward as necessary as you would like. So what do I mean by that? Most of you are familiar with this. The reports do state if it's in a high, if it's in a very high fire hazard zone. Again, let me restate that correctly. The reports do identify if it's in a very high fire hazard zone, but the reports in the page, the front of the report, the actual disclosure page itself does not distinguish between high and moderate. So if it's in the high or moderate, it will be in a wild fire area, and that will be checked, but it won't be listed as a high fire hazard severity zone on the front page. So if it's in a wildland fire zone, you've got to go into the body of the report to see whether it's high or moderate, because if it's moderate, the defensible space compliance requirements do not kick in. If it's high, they do. So if you have any questions on that, once in a while, agents have called me and sent me the NHD. Happy to review it for you. It's usually toward the front. You know, they break all of those disclosures they make. They then, in the body of the report, have a discussion about each line item in the disclosure page itself. So you'll find that deeper into the report. That is probably the best way to determine that. You can also call your rep directly and ask them what they, what zone, whether it's high or moderate. All right. So kind of zooming through here, there is a viewer also that you can click on, and there's the website. It's on the form. And so you can go to www.fire.ca.gov/DISPACE, and that will give you a viewer. You can type in the property address and it will tell you whether it's in a high or very high fire zone. That's, that Carr now believes that viewer is pretty reliable. Okay. All right, so let's talk about fire hardening. Again, the 4 conditions must be met, and it's a 1 to 4 residential units. A TDS is required, and it is built prior to 2010, and of course, it's in a high and very high fire zone. Okay, so if those 4 conditions are met, then you need to complete this form. And the first portion of the form contains a statutory notice required in all transactions that meet the criteria I just outlined, that this notice be provided the buyer. So that notice is codified, it's in the code, and it's right there on the form. So that takes care of your requirement to give the buyer the notice. The part that you're going to be interested in is the fire hardening vulnerabilities. Now, they've improved the form quite a bit because they've made it more like a TDS, and they've made it more clearly. They've more clearly stated that is the seller aware of something, yes or no. So again, it's seller awareness. It's not a disclosure of actual fact of the condition of the property. It's a disclosure of the seller's awareness of the condition of the property. And the old form, you didn't even know if the seller even reviewed it because there was no place to say no. There was just places to check if you were aware of the problem. And so if you weren't aware of the problem, there was no way to indicate that. And so there's a lot of questions about, did the seller even complete this? Because the whole thing is blank. The new form eliminates that. So this is a big improvement on the new form. So you want to go through this with your seller, or have your seller go through it. And again, is the seller aware of these features that make the home more vulnerable to wildfires? So eaves, soffit, roof ventilation, where the vents have openings in excess of 1/8 of an inch are not flame or ember resistant. I would argue, so you answer that either yes, or you answer that either no. I'm going to suggest that a lot of your cellars aren't going to have a clue about the answer to that question. Roof coverings made of untreated wood shingles or shakes, yes or no. I would argue most sellers should be aware of that. Again, this is a seller disclosure. So if the seller says he's not aware of it, but you know it's a wood shake roof, you might ask the seller to reconsider his or her awareness, because they should be aware of that, of course. Is there combustible landscaping or other materials within 5 feet of the home or under the footprint of any attached deck? In other words, attached decks that are raised, a lot of time people store flammable stuff under there. And so either yes or no. Single pane windows, again, I think most sellers should know that answer, yes or no. Loose or missing bird stopping or roof flashing, most sellers are not going to know about that. They're probably going to check no, they're not aware of it. And again, when you talk to a buyer, be sure your buyer understands that doesn't mean there isn't loose or missing bird stopping. It means the seller's not aware of such a thing. And then finally, rain gutters without metal or non-combustible covers, yes or no. All right, so when you fill this out, it could look something like this. Each question, just like a TDS, must be answered. And so if any one of these are not answered, the form is not complete. So you want to look at, you want to see 6 check boxes. And if it's not checked, then go back to the listing agent, go back to the seller, and again, explain to the seller, well, the seller says, yeah, I don't know. Well, it's not whether you know or not. Are you aware of it? Well, I'm not aware of it. If you don't know, you probably are not aware of it, and you could check no. All right. So defensible, so that takes care of the fire hardening part. That is fairly straightforward. That's not too complicated. Most people are not having much trouble with the fire hardening portion of the previous FHDS. Where the problems lie is in the defensible space disclosure and addendum, because the civil code is somewhat complicated, and it adds to, there are local ordinances that also impact defensible space disclosures and addendums. And so it becomes a little more complicated for a lot of agents and for, I would argue, a lot of sellers to understand understand this portion of the FHDS. So what they've done is they streamline this form a little bit, organize it in a better fashion. And I'm going to, by the end of the class today, if you have any questions at all, I'm going to give you a little summary that in most cases will be very straightforward on what the seller should probably be doing in filling out this form. Okay, so paragraph 3 is required if the 3 conditions are met. The one condition that does not need to be met is the date of construction. So the other conditions, if any one of those are not met, then the defensible space disclosure is not required. Again, 1 to 4 residential units, TDS required, and in a high or very high fire zone. So if any one of those conditions are not true, you can omit this form as well, this portion of the form as well. Okay, so to help sellers fill this form out, there is a defensible space decision tree. It looks at first blush a little complicated. Hopefully we'll have enough time I can zoom through it, but if I don't, it's going to be okay, because as I've said before, you're going to have a summary at the end of this section that's going to pretty much answer the same question that the defensible space decision tree answers. So hopefully that'll will be helpful to you. So local compliance requirements. Now, this is important to know. This is not an awareness question. The seller is not, well, let me phrase that differently. The seller is obligated to tell the buyer whether the property is subject to local vegetation management. And so this is, this is not a, gee, I don't know, so I'm not aware. So you notice it doesn't, nowhere does it say not aware. So your 2 options are either yes, it is subject to local vegetation ordinance requiring defensible space around improvement of property, or no, it is not. So that's going to be a statement that the seller is going to need to know. In general, any property in any fire zone in the county of San Diego is going to be yes. So when in doubt, you'd probably check that box. Now, if you got a property in downtown San Diego, it would be not subject to local vegetation management because there's the vegetation management in the heart of the city, that there is none. But if you are in any kind of a fire zone at all, you're going to probably be is. So if you have any question at all, you can call me. In general, you have a question, it's probably because you are in a fire zone. And so this is probably the recommended answer to this question. You know, for sure, most of Escondido is, if not all. For sure, most of East San Diego is. Rancho Bernardo, Scripps Ranch, you know, San Marcos is, Vista is, Fallbrook is, you know, Carlsbad is. Our market is going to, you know, be mostly is. Now, like I said, you list a condo next to the ballpark downtown, you'll be able to say is not subject to any local vegetation management ordinance. Pacific Beach doesn't have any. Mission Beach doesn't have any. I think La Jolla does. So if it's in La Jolla, you probably are going to say is. But again, check with your natural hazard disclosure, see if it's in any kind of a fire zone of any kind. You know, wild land fire, yes, is subject to vegetation management ordinances, either passed by the city. I've reviewed the city of San Diego's in detail. I've reviewed the Escondido in detail, and I've reviewed the county of San Diego in detail. And so even if you're not in one of the two cities, Escondido or San Diego, you are in the county for the most part. So that is probably going to be the default answer right there. All right. So if paragraphs 3B and 3C must be completed regardless of the answer to this question, if the conditions in 1B are met. And so 1B, where it lists the requirements for a defensible space disclosure and addendum, those three requirements, 1 to 4 residential, TDS, high or very high fire zone. So hopefully that's pretty straightforward. Seller's representation of the property compliance. Now, this is a awareness section. 3B, whether it be 1, 2, or 3, is an awareness. 3A is not an awareness. It's a statement of fact the seller must tell the buyer. 3B, the seller gets to say, well, this is what I'm aware of. Now, I would argue that most sellers are probably not going to be aware whether the property is in compliance with state and local defensible space law. This is, you know, and you notice this is a default because Carr, you know, believes the same thing. Most sellers don't know all the regulations for compliance to vegetation management, and so they're probably not aware whether the property is in compliance or not. Now, this would assume, of course, they do not have a report. Because if they have a report, they're aware of it. I mean, you know, if they've got a report, even if they haven't read the report, they are in fact deemed to be aware of it because they're in possession of a report regarding defensible space inspections. Okay. Now, the other option is the seller is aware. You know, they are aware, and they believe that they're in compliance. Now, this would be that the seller has documentation of the compliance. So what does that mean? That means that if the seller went out on their own and had CAL FIRE come out and look at it, if they got a recent building permit and they were required to get a report, and the report said, yeah, you're in compliance, then they're going to be aware that they're in compliance, and they're going to have to deliver the report to document that. All right. And the time specified is within the first 7 days, whichever is last, 3 days or 7 days of opening, of accepting an offer. Okay. Now, if paragraph 3C, if this paragraph is also checked, then paragraph 3C will probably apply. We'll get to that in a minute. All right. Now, property is not in compliance. Be very careful with it. Oh, no, I'm sorry. Let me back up. Be very careful with the fact that the property is in compliance. If the seller doesn't have documentation, it's in compliance. Don't say it is. Now, if the property is in compliance, but that the seller says it's not, I'm not too worried about any damages to the buyer. Gee, the seller told me it was not in compliance, but it turns out it was in compliance. There's no monetary damage to a buyer for that. So checking this box in error is not nearly as problematic as checking box 3B2 in error. So be careful with that. More likely, you're not going to check either box. The boilerplate is going to be the one that applies because the seller doesn't really have an inspection, hasn't had an inspection, and doesn't know. And, a year from now, 2 years from now, that will begin to change as more and more properties are inspected. But right now, we're in a situation where I would submit 9 out of 10 sellers do not know if their property is in compliance with all the state and local defensible space law. Okay, now, if the seller has or agrees to obtain a report by an authorized inspector, the seller shall deliver that report within 3 days or 3 and 1, which is 7 days. Okay, so like I said, the second point you want to leave here with this is the seller is unaware of whether the property is in compliance with applicable state or local law. That's going to be generally what your form is going to state, and you don't have to do anything because that's in the default position. Most sellers are not aware of it. So that's going to cover you as far as 3B. Now, where the real confusion lies for many, but here's the good news, it's really pretty simple in San Diego County. And I'm going to review that in a minute, but the confusion lies in the buyer and seller agreement regarding which party shall obtain compliance with applicable state and local defensible space requirements. State law says, it says two things. One is it says that any property in a high or very high or moderate fire zone even must comply to certain defensible space requirements. That's true of any property, whether you sell it or not. State law says that if you sell the property must be brought into compliance within either prior to the sale or within 1 year of close of escrow. And state law allows either party to be responsible for that. So it makes sense, especially if you're a listing agent, that since the buyer can bring the property in compliance after close of escrow, that the responsibility is shifted to the buyer. So the buyer needs to understand that when they buy a property that is in a high or very high fire zone, that they are going to be according to state law, be responsible for ensuring the property is in compliance within 1 year of the sale. One of the reasons the state did that is they didn't have enough inspectors. If they said that the property had to be in compliance prior to close of escrow, we would be looking at 3-month escrows at a minimum because every seller would have to get an inspection and the backlog would be horrific. So the state was somewhat pragmatic by saying, look, there's no way that we can require a seller to delay selling their house to get this report because we don't have enough people to do the inspection. So we're going to require these inspections and we're going to require a statement of compliance, but we'll allow the buyer to do it within 1 year of the sale. And so that is, that's how the law is written. Now, the law also says, and this is where we're getting a little bit of confusion, that it could be a point of sale requirement. In other words, the law does say, it could be required to bring the property into compliance prior to the close of escrow. And here's the big if a local jurisdiction says so. In other words, there's a local ordinance that says the property must be brought into compliance as a point of sale requirement. Now, here's what I can tell you to get right to the point here. That is a rare situation. There are a couple of localities that do have that. Truckee, for example, has that. I think Santa Barbara might have that. Places that have been devastated by fire, not that San Diego County hasn't had our own problems, but certainly Truckee has had a far more severe problem. So they want compliance to be documented in order to sell your home. But the county of San Diego has no such ordinance. The city of San Diego has no such ordinance. Escondido, the city of Escondido has no such ordinance. San Marcos has no ordinance. Vista has no ordinance. Fallbrook has no ordinance. Like I said, the county, many of these jurisdictions defer to the county. The county does not have a point of sale requirement. They do have an ordinance that you must maintain your property, your vegetation, but you don't have to document it in order to sell your house. So, I've sort of, given away the rest of this section of the presentation. You can hang out a little longer and get a couple more slides that'll help you understand it. But you're going to see how in San Diego County, this is a pretty straightforward situation for us. Okay, so this section of the form 3C is documenting or memorializing which party must obtain compliance, because the state law does require that the property be in compliance within 1 year of the sale. It can be done by either party. Well, the seller's not going to agree to bring it into compliance 6 months after close of escrow. So it's pretty logical that the buyer is going to assume that responsibility, especially in a market like we're in today. Okay, so the default, which, statewide CAR believes is most common, it is not common in San Diego. So you will not go with the default. You will be checking one of these boxes. There is no local ordinance, and the buyer shall obtain documentation of compliance with the state. The county has a ordinance, so there's not any jurisdiction in the county. In the county, there's not a single city that's not affected by the county ordinance. So we do have a local ordinance, at the very minimum, countywide. They have it called Coronado. I'd be surprised if Coronado had any ordinance, but it's in the county of San Diego. So therefore, this would not apply. And so you're going to have to check one of these boxes. Now, don't panic, because the good news is, unless you negotiate some other term, it's going to be straightforward. You're going to see in a minute which box to check in almost every situation. So, the buyer will still have to obtain documentation of compliance because there's a state law, as I just reviewed. Okay, and they have to do that within 1 year close of escrow. Okay, now 2, buyer responsibility. In other words, we're going to make the buyer responsible because the law allows either the buyer or the seller to be responsible. The law states that the buyer and the seller must have an agreement as part of the sale. That's why this is also an addendum. This form, let me make sure everybody understands that. The FHDS, if it applies, must be in every transaction, especially if you're the listing agent. Why? Because the seller could have liability after close of escrow if there is not an FHDS checking one of these first 3 boxes. We're checking the second and third box. Box 1 is a default, doesn't apply anyway. But if the buyer does not accept responsibility, CAR, and they're certainly smarter than me, but I agree with them. I've looked at the code pretty closely for more than a year, and I think the way the code's written, that if the buyer and the seller cannot come to an agreement, and then later the buyer discovers they got to bring this property into compliance, they would have a cause of action against the seller. So do not allow a transaction to close with that it is in a high or very high fire zone. TDS is required. 1 to 4 residential units, just those 3, without this section being completed. Okay, so buyer responsibility, there's the ordinance in effect which requires compliance as a result of a sale of a property. Now, don't be confused. You will never, right now, I'll announce if it changes, you'll never check box C2. Why? Because there is no local ordinance that I have found yet in the County of San Diego that requires compliance as a point of sale requirement. I will tell you that City of Escondido, I've talked to the attorney of both cities, the attorney office in both cities, Escondido and San Diego. They kind of think there is one, but they cannot produce one. And Carr has confirmed to me that they don't believe there is one. They're not aware of one. And the fact that when I asked to get, I asked the city attorneys of both of these entities to give me, the ordinance number so I can look it up, they give me the state law. Well, the state law, they don't read it in its entirety. I'm kind of surprised because it says, yeah, it is required if there's a local ordinance that says it must be done. And they can't give me the local ordinance. So this probably does not apply. Well, right now it doesn't apply anywhere in San Diego. All right. So, but it does allow, if the ordinance were, the ordinances that do exist do allow either seller or buyer to obtain documentation, then the buyer could be responsible. There are ordinances in other localities where the seller must obtain the documentation. We do not have any local ordinance discussing a point of sale compliance requirement. So this box is not appropriate. All right, now, box 3. Buyer responsibility, local vegetation management ordinance in effect. That is true. County of San Diego has a local vegetation management ordinance. And I've told many of this, I don't want to bore you again, but I got caught up in it with my insurance company. I had firewood too close to my house. That's a violation of the county ordinance, the state law as well. And that was in effect, but it does not require me to move the firewood as a result of selling my house. I have moved the fire, by the way, my insurance company, plus common sense told me, I guess having a big couple of cords of firewood right up next to my house, probably pretty stupid in Scripps Ranch. So there is local vegetation management ordinance effect in San Diego County, but they do not require compliance as a result of a sale of the property. That's important to keep in mind. So if the other side tells you, oh yeah, no, you have to do this, call me and I will be happy to, discuss with them or their management. And again, I would say, okay, please provide me a copy of the ordinance. By the way, if you do have that and somebody does insist, let me know. And if they do send you a copy of the ordinance, for heaven's sake, let me know, because they might be ahead of me by a day or two discovering this. I've checked periodically with the county, city of San Diego, city of Escondido, to see if there's any compliance as a point of sale ordinance, recently passed. Haven't had any yet. All right. The buyer will obtain documentation with the state defensible space law within 1 year close of escrow. That's, that must be done, and it'll be on the buyer, or if applicable, comply with local requirements after close of escrow. All right. So paragraph 4, 5, and 6 shift the responsibility to the seller. And again, local vegetation management ordinance in effect, we have such a thing, which requires compliance as a result of sale of property. We do not have such a thing. So you will not be checking box 4 in the local, this is for, statewide form. So these other caveats helped explain this, but just from the get-go, 4 is not going to be checked. Seller responsibility, state or local compliance already complete. Now, this could be a possibility. So the seller went out and had his home inspected by CAL FIRE. They got a report, and then they already completed any improvements to the property to be within compliance. So, they must have had this documentation within the past 6 months, and then they deliver that documentation to the buyer. This is going to be rare today, and over time, a year from now, a year and a half from now, 2 years from now, this will become more and more common. I don't think it'll be yet that common, but we'll start seeing more of it. I haven't seen any yet, but I've had a couple of agents tell me that the seller went out and got an inspection because they either thought they would have to, or they agreed to do it because the buyer wanted them to do. So 5 might apply in that case. And then seller responsibility. A seller agrees that they will get documentation. I would say if it were a buyer's market, you're going to see box C6 checked from time to time, more often, depending on how strong a buyer's market we're in. But in a seller's market, even today, we're still somewhat of a seller's market. Buyers are probably not going to be requiring or asking sellers to get compliance. By the way, if the parties can agree to what's in the FHDS, especially this section, because this is the addendum section. This is where a buyer and seller are agreeing. This is what we're going to do in our transaction. If they can't agree, either party can cancel. So one way to avoid that is to have this be part of your counter. Carr was initially recommending it. They've since changed their opinion. I'm not that concerned either way. I'd get this out quickly, because if the buyer is not going to agree to what the seller wants, or vice versa, the seller's not going to agree with what the buyer wants, you're going to want to know that early in the transaction. Okay, so here's the takeaway. You're going to check box 3 probably in most cases, unless the seller has already gotten a report, 3C5, or the seller agrees to get a report, which is 3C6. I would say in this market, both 5 and 6 probably are not going to be very common. So you're going to check this box. It's in a high or very high fire zone. TDS is required as 1 to 4 residential units. Buyer is going to be responsible to comply with local vegetation management, because there is not a compliance requirement as a result of the sale of the property. That's our situation. I think I've probably beat that to death, but I want to make sure everybody is comfortable with that and has a pretty good understanding of it. Okay, now, 3D, if you do have a report, then you provide the report or state where the report can be obtained. And the requirement to provide documentation of the defensible space is only applies if there's a state or local agency or government entity or qualified nonprofit entity that can do inspections. We do have those in our area, so we have entities that can do the inspection. So that's probably not going to be of concern to us. And then finally, the final inspection report disclosure. If the seller has a final inspection report, then they should provide it or state that where they can get a copy. Right now, probably the most common reason the seller is going to have one is because they made improvements to the structure after 2010. And most building departments throughout the county are requiring confirming compliance with defensible space if it's in a high or very high fire zone. And so, I put a room addition on the back of my house in 2015. My permit might have required me to get defensible space inspection and confirmation report as part of me getting the permit. So I'm going to have that report. Now, if it was in 2015, I'm being hypothetical here. I didn't really do that. But if I did in 2015, if you knew me, I didn't throw it away. But if you also know me, it might take me a while to find it. So I might just say, okay, I don't have a report, but you can get it from, because I have a record of who I paid money to or who I had generate the report for me. Okay, and now the seller, I'm sorry. Oh, gee, I'm zoomed ahead here. The seller represents that the seller has provided the answers on paragraph 2B and 3B in this form based on the seller's awarenesses, not A, that's a statement of fact, but the rest is on the seller's awarenesses. That's just a stating once again that the FHDS is for the most part what the seller is aware of. Okay, so summary. And boy, if you all check out after this, I'll understand. I'm going to try to zoom through the balance of this class quickly. I don't think I will go into the defensible tree in detail. I want to answer questions. But this is what you need to know in summary. Okay, that if you're in a high or very high fire zone, there is a local compliance requirement. It's not a point of sale necessarily. Well, it isn't, but you are affected by vegetation management ordinances. So you're probably going to check in 3A, you're going to check is. That's going to be pretty common if you're in a high or very high fire zone. And hence you have to do this report. Also, in general, you're going to be take some comfort in the fact that 3B1 probably applies, and that is the seller doesn't know whether his property is in compliance or not. Now, if the seller is aware, in other words, has a report, I forgot the other thing at the end. If the seller has a report, then he's going to be aware. He can't have a report that says he's not and then say he's not aware of it. That won't work. That's called constructive fraud. Constructive knowledge is knowledge you have, or more importantly, should have. So, for example, a seller gets an inspection report and the buyer cancels, and now he passes that inspection report he keeps the inspection report, doesn't give it to the second buyer, and claims he doesn't know what's in the report, so he didn't disclose what's in that report. He has constructive knowledge of that report. So the seller has a copy of the report. He hasn't read it, but that's not a defense. It's constructive knowledge. I didn't want to get in the weeds here with the law. I confuse you. Don't worry about it. If the seller does have a report that says he's not, then he can't say he's not aware. He's unaware, in other words. Okay, so unless the seller is aware and in other words has a report, then you would check either 2 or 3. Okay, and then finally in 3C3, you can check this county-wide, and I'll alert. We'll do a blast through Agent Hub and probably do it multiple times, because as soon as I discovered that one of the local jurisdictions and or the county changed the law and made it a point of sale requirement, well, then C3 will not apply. And then we'll revisit this and I'll tell you what box you should check. But Carr tells everyone, and they're right, 3C3 is going to be the most common situation, because point of sale requirements at a local level, one does not exist at the state, and at local level, they're very rare. Okay. I hope that kind of answers your questions in general on how to do the FHDS. The Defensible Space Decision Tree, it's basically a form that you answer questions, and then, by answering the questions, it tells you what to do on the form. So the purpose of the form is to help you complete paragraph 3. And the good news is for us in San Diego County, paragraph 3 is pretty simple. So, but if you wanted to take some time and go through that, you could go through it just to be sure you're answering all the questions correctly. For paragraph 3 to apply, these 3 conditions have to be met. Of course, we've talked about that multiple times. The 1 to 4 residential units, seller required to do a TDS, and in a high or very high fire zone. If any of those conditions are not met, then you don't need to do, go through do the FHDS. It's not required if it's not in a high or very high fire zone. At any time when you go through this form, if it says then sign form, you're done. You've completed the FHDS if you've answered the questions and transferred that information to the FHDS. So in this form, the DSDT tells you to sign the form. It's saying there's nothing more that you need to put on the FHDS. So there's a series of questions. I'm just going to zoom through this. So step 1 is the property located where vegetation management ordinance requiring space around the property to be maintained. So if it's yes, there is a box, then you go, you check the is box in 3A, and we talked about that. I've already advised you to do that if it's, and so remember, that's what I blocked out for you. So you're going to check that box. If it's no, you're going to check the box not. You should not do that. If it's in a high fire zone in San Diego County, there is vegetation management. So you should not do that one. But if you're in a different area, say downtown San Diego, as I said, you might be able to check that box there. If the seller does not know, he has to find out. So that's where you will be very helpful, but you can direct the seller to basically, I would say, contact the Natural Hazard Disclosure Company, review the Natural Hazard Disclosure Report. That's going to tell you. All right, so it's pretty simple. If it's yes to step one, does the seller have a report? And then it's going to be a series of answers. The answer is a report, and the report documents the properties in compliance. And then it's going to tell you what boxes to check as a result of that. Or yes, the report documents the property is not in compliance. And then it will tell you what boxes to check in that. And if no, the seller does not have a report, then 3B1 applies, and you go to step 3. 3B1, seller is unaware because he doesn't have a report. He doesn't know if he's in compliance or not. So it's pretty straightforward. I'm zooming through this so fast, you might be confused only because I'm going fast. But if you go back and go through the DSDT, you'll see that it's pretty easy to follow. And again, if you don't want to do the DSDT, you're probably going to be fine because of the summary that I just gave you as to what boxes that you should be checking most of the time, unless you have knowledge that something's different. So you skip if the question is no, if the answer rather is no in step 1, then you skip step 3. So is it properly located in an area where the vegetation? No. So then you would, skip the rest of that section. Okay. Does a local law require compliance with the law as a result of sale of property? No, it doesn't. No, it does not. And again, seller, you go through that. No, seller, see, the first one is seller does not know if the property is in compliance, and there is no local ordinance. No, there's no local ordinance, and the seller knows the property is in compliance. Pretty straightforward. In interest of time, I don't want to spend a lot of time on this because you don't need to really concern yourself a lot. Now, this is something that's pretty important, though, and you should be doing this anyway. The buyer should be advised as a result of an FHDS. The buyer is, by law, going to incur bringing the property into compliance, incur the expense of bringing the property in compliance within 1 year. And so the buyer should be aware that, that he should find out how much it might cost to do that. Now, here's what's an important caveat. The buyer cannot, without the seller's permission, have a government entity inspect the property. So what do? Well, the first thing is ask the seller if he would allow a government entity to inspect the property. There's no requirement to bring it into compliance as a result of selling the property. But the seller may not want a government entity to inspect the property because he feels more comfortable not being aware of any non-compliance. So the buyer could ask the seller, can I have a government, CAL FIRE come out and inspect? The buyer cannot call CAL, well, he can, but he should not call CAL FIRE to come out and inspect the seller's property without the seller's permission. You can hire a private entity to inspect, and that is perfectly okay, or, get some idea of what it might cost to bring that into compliance. So the buyer should at least be aware that that could be a cost he's going to incur later. Okay, so does local law require compliance with the law as a result of sale of property? No, and the seller does not know. And the seller agrees that he will bring the property into compliance. Well, then you check unaware, and you check C6. I'm not aware, but I agree to bring it into compliance. So the seller is saying, okay, I don't know if it's in compliance or not. The buyer wants me to bring it into compliance, and I'm okay doing that. Well, so then that would be the series of boxes you would check, and then you would provide the final inspection report. Does the local law require compliance? No. And the seller knows it's not in compliance, and the seller agrees to bring the property in. So that the difference is the seller does know it's not in compliance. Previous box, he doesn't know. So when you read this kind of carefully, you see it is pretty straightforward. So the property is not in compliance because the seller is aware of it. See 3A, I'm sorry, 3B3. You know, the default is the seller is not aware, but if the seller is in fact aware and knows that it's not in compliance, you would check that box. And the seller agrees to bring the property into compliance again, and you would provide a final inspection report. The other caveat I want to give you is the seller is advised to find out how much it will cost to bring the property into compliance before he agrees to do it, because it could be significant. And the law allows the seller to sell the house without bringing it into compliance as long as the buyer agrees to assume the responsibility of bringing it into compliance within 1 year. So there's these two areas here, 3C3, the advisory, and 3C6, the advisory that goes with those two statements. Pretty important. Now, is there a local law? If it's yes, then you go to step 3.1. There is no local law that requires compliance. So, you know, you only got these two options up here. I mean, you know, those two options are the only ones that really affect your sale. There is no local ordinance that requires a point of sale compliance. Likewise, in 3.1, that doesn't apply. Why? Because local law does not require compliance with the law as a result of the sale of the property. Hope that's pretty clear. There are local vegetation management laws in effect. Keep that in mind. The local laws do not require compliance with the law as a result of the sale. They just require the property be in compliance, period. Just like you're supposed to have low flow fixtures in any property in the state of California, period. But it doesn't mean you have to change them in order to sell the house. You can sell a house that's not in compliance with the water conservation code. So that's the difference. It's not required as a result of the sale. It's just required in general, but a seller is perfectly legal to sell a property not in compliance. All right. Hope that's pretty clear. Step 4.1 does not apply either. So I'll make this these slides. I'll simplify them a little bit and make them available as a handout in a few days, maybe by next week, by Monday. Okay, so how do you find out if the seller obtained documentation? Well, you can ask for a report, or the buyer can ask the seller for a copy of the report, and the seller who obtained a report but did not keep a copy can contact the inspector to prepare a certification as a result of having gotten a report. How to find out the property is in compliance? If you're going to hire a government authorized defensible space inspector, you have to have the seller's permission. Okay, buyer or the seller can hire a non-governmental defense space inspector to prepare a report, and the buyer can do that as part of their investigation step. Okay, the wildfire advisory, very quickly, and I'm going to wrap it up. I'm not going to go through this paragraph. I'm going to talk about each heading. Just you want to review this with your seller. So they talk about concerns and issues. They talk about an advisory to buyers or tenants. They talk about resources available to the buyer. They talk about fire hardening and defensible space advisory. And the buyer and the seller acknowledge that the real estate agents and the brokers have no authority or can offer expertise in providing guidance as to investigating whether the property is in compliance or not. So that wraps it up. I hope you didn't get confused too much by the DSDT. I quickly went through it. But my point being, you can do the FHDS fairly straightforward once you determine that you are in a high or very high fire zone, because we have no local ordinance requiring point of compliance, a point of sale compliance. All right, Lindsay, do we have any questions?
Ron asks if we've already supplied the old form but have not closed, do we have to provide them the new form?
No, you're okay.
Kind of a question along the same lines. Heather has a property closing tomorrow. Does she need this current form completed? We have the other one in the file.
No, if you have the old one in, you're fine.
Susan says, do you know the approximate cost of getting this report? Not quite sure what she's referring to, but
I believe if you get it from CAL FIRE, it's free. Does anybody online know that? Ron? Unmute yourself, Ron. You're muted, Ron. Oh, it's too bad. Ron, you're muted.
There we go. Okay, I just got one, and it's very not painful at all. You go to the fire department, the city fire department website, and you fill out a form, and the agent can do it. You fill out a form with that form, and that goes in to the city. The city contacts you within 4 days and says, we received it. And then within 10 days, they come out and do the report and send you a letter saying you're in compliance or you're not in compliance. Very simple, doesn't take that much time. I mean, unless you have an escrow that's less than 14 days. But it's very easy. And now this was on a condo complex, which I did it. So, I mean, but it's very simple.
Thank you, Ron. And keep in mind, I'm not here to tell you, not to be cooperative with the buyer and not to accommodate these kinds of requests from the buyer. I'm just defaulting to the fact that most sellers probably do not want to incur, although those, the expense is really not in the inspection, it's in bringing the property into compliance, and or the administrative delay that it might take. But if a seller is open to doing that and the seller has some concerns about that, then follow Ron's guidance. I mean, it's a pretty straightforward process. Do keep in mind that there's a time factor. They've improved the number of inspectors that are out there and the ability for these agencies to do inspections since the law was passed. Once they get up to full speed, this law may be modified and it might become a point of sale requirement. But go either route. But
it's also free.
Yeah, that's what I thought. I thought the inspection from the government's free. Any other questions?
Brian wants to know if the FHDS is completed, do we still need the WFDA signed as well?
Yes. In fact, you all heard it first here. We're going to make that a required form in the broker file checklist for any property that is in a high or very high fire zone, and I might even extend it to anybody that's in a wild land fire zone, that the buyer get the advisory. And that's especially important if you represent the buyer. We have no obligation to advise the buyer when we don't represent them. There are not, knock on wood, Walt, there are not a lot of lawsuits regarding fire hardening and defensible space yet. So if you have the seller and you don't give the buyer the advisory, I'm not losing any sleep over that. A juxtaposition that against mold. There's tons of mold lawsuits all the time. So we don't care who you represent. We want the buyer to have signed a mold advisory because we want to use that as a defense. If the lawsuits begin to pop up all over the place over fire hardening and defensible space concerns, then we might want the WFDA required in all transactions. But right now it's a buyer advisory. So it's going to be required when you represent the buyer and the properties in any fire zone at all. Great question though. Thank you.
That's it.
That's it. All right, folks. If nobody else has any questions, we started a little bit late, and so we're ending about the same amount of time. So we've kept it to just about an hour, so that's good. And thanks for joining us today. And if you have any questions at all, don't hesitate. Give me a call. Like I said, I will add to the handout by streamlining my notes a little bit so that you have a reference. And Lindsay will probably post this within a few days. Hopefully we don't need to do too much editing.
Nah.
Okay. Have a great day.
Thanks, Walt.
Thanks, Walt.
You're welcome. You're welcome.